Hi everyone, it's Karen Cole here, and we're going to look at the Bryan Kohberger's case. Has the judge really paused the case? To get us started, we're going to listen to a short clip from an Idaho news channel.
Tonight, a judge is giving the man accused of murdering 4 University of Idaho students time to review case materials. Bryan Kohberger's attorneys filed a motion to stay proceedings in the case, which basically means pause everything. Today, the judge granted him a 37-day stay to allow him and his defense team to review material from the grand jury that indicted him. The judge says this motion does not affect any other aspect of the case. Kohberger's trial is still set to begin in the beginning of October.
Well, you just heard it there, folks. They are saying it essentially means to pause everything. Well, that's not my interpretation, and I'll explain to you what I think the interpretation is. And I'll do this by comparing the order made by the Latah, Idaho judge on the 10th of July, 2023 with Idaho laws, and what would happen in the UK, England and Wales, as the concepts are very similar. In the UK, a stay in proceedings can be brought by either the prosecution or the defense. It can be asking the court for some extra time for something to happen, which is exactly what just happened. And in the Bryan Kohberger case, the defense requested that the court allow some time for the grand jury transcripts to be disclosed to them, and that's what they asked the court. And later on, I will share an example of when a prosecution requests a dismissal with liberty to restore. Oh, and I found this perfect statement from the Right Honorable Lord Lane that sums up the imposing of stays perfectly, and it changed my opinion, and it might change yours. But before we get into that, let's look at the Idaho laws. So let's look at what just happened. The court granted Bryan Kohberger's legal team their request to have the grand jury transcripts, and now those transcripts must be provided by the 21st of July. That should give them time to prepare for trial. And the judge also said that it may be necessary to move the trial date in the future if it is needed by the parties. Now, this is because the state of Idaho, the court has broad discretion to stay proceedings. In determining whether to grant a motion to stay, it calls for an exercise in judgment, which must weigh competing interests and maintain an even balance of fairness to both parties, both sides. Though Bryan Kohberger's alibi still needs to be submitted by the 24th of July, 2023, so there is no pause in proceedings. And I will tell you why this is so important, that the judge will be allowing either party to move the trial date in just a second. But first, let me tell you about the legal standard in England and Wales to stay proceedings. Well, it is the court's general common law power, and it is done to protect the process of both law and justice. So the court has a duty to ensure there is no unfair treatment of those who are brought before the courts. So what the judge in Bryan Kohberger's case has done quite brilliantly is he protected both the defendant's constitutional right to a speedy trial and the prosecution's deadline to prosecute before the deadline ends. And the judge spelled this out in the order so that there is no uncertainty. He actually wrote, if either party needs extra time, the court will move the trial date set for the 2nd of October, 2023, meaning the court has extended the 6-month speedy trial. And I'll tell you why this is so important. This judge isn't called Judge for no reason. He's excellent. Americans have a constitutional right to have a speedy trial. However, the Constitution doesn't actually specify the length of time. Thus, this is why each state enacts their own laws. So the Idaho law of a speedy trial is 6 months from the date of arraignment, and Bryan Kohberger was arraigned on the 22nd of May, 2023. So there is still a bit of wiggle room, and the judge extended the speedy trial date by 37 days. which means that Bryan Kohberger has not waived his right to a speedy trial, and the state must still bring him before the court within that time frame. So, in my opinion, this is just another example of the case is not paused. Think of it this way: the court is prepared to extend that legal standard. On a side note, if the prosecution has not got all the evidence to secure a conviction, they can ask the court for a stay, which could be given with liberty to restore, with or without prejudice. And this is what has happened in the missing Colorado woman Suzanne Morphew's case. Let's listen.
These text messages are very damning, and it just continues to raise questions as to why the prosecution decided to dismiss the case.
But Barry could be tried again unless a judge changes the ruling and dismisses the case with prejudice. Lowe says these new messages could keep that from happening.
The prosecution and law enforcement is essentially saying, wait, hold up here. We still think this is the guy who did it. We don't think that you should be dismissing this case with prejudice.
So you can see from that clip that there is protection if offending behavior is not statute bar. And killing someone is pretty darn serious. So there is no statute of time limitations for indictable offenses on the prosecution. And we see this all the time in cases where the suspect is brought to justice years later. In the UK, you have to have a right to a fair trial, not a speedy trial like in America. Serious crimes are viewed differently, and they take priority in the courts. So the courts could be delayed for good reason. Think of it like this. If you've gone to accident and emergency with a broken arm, you might be sitting there for hours and bumped in the queue because someone with a stab wound or a heart attack comes in. In England and Wales, the courts are backlogged. As of September 2022, they were backlogged by 28%. And in 22-23, the reasons for some of the backlogs are to do with the court's constraints on the number of cases the courts can actually process. And the issue is the availability of judges and barristers. So to address this, the court has been recruiting judges. I have left links below if you're interested in knowing more. However, don't kid yourself, the courts are not going to hand out dismissals and stays without good cause. Now, this is the perfect time to read to you the lead authority on this issue of excessive delay. Lord Lane, a leading authority, says that if a delay is the fault of the defendant, then it should never be the foundation for a stay. His lordship went further and said stays imposed on the grounds of delay or for any other reason should only be employed in exceptional circumstances. If they were to become a matter of routine, it would be only a short time before the public understandably would view the process with suspicion and mistrust. And let's not forget, it wasn't long ago when Lori Vallow-Daybell tried to argue that her case should be dismissed for breach of her constitutional rights to a speedy trial. Oh boy, thank goodness the jury found her guilty, but I wouldn't be surprised if her defense tries to appeal. I've left a link if you want to read their motion to stay, as it's quite interesting, and you can see for yourself. Well, I hope I helped you to understand what just happened in the Bryan Kohberger case. My view, they have not paused it. The parties will be working from morning till night tirelessly. The defense may find issues with the grand jury transcripts, so we could be back here again. Why not tell me your thoughts? I enjoy reading your comments, and our community is growing. So if you're not yet subscribed, please do so by hitting that subscribe button. It's absolutely free. YouTube will then share it with more viewers. By subscribing, your name is not publicly shown, but it will be if you leave a comment. And Okay, I'm going to disclose something to you. I didn't know how to leave a comment on YouTube. And then our guru, Crime Time with DutyRon, said if you're not signed into YouTube, you can't leave a comment. So sometimes just knowing that little bit of information is really helpful. And once you leave a comment, it's your free way for your voice to be heard. People will see your name, so be careful. Well, I hope you found today's video interesting, and information is power. Why not subscribe and watch more of our videos? If you need legal help, contact legal-minded friends.